Shortly after 10 a.m. on November 18, 2003, in a 50-page ruling, the Massachusetts Supreme Judicial Court found that the state may not deny the protections, benefits, and obligations conferred by civil marriage to two individuals of the same sex who wish to marry.
I got my copy in the lobby of the courthouse, ran outside to start thumbing through it and reading it, and I actually got to a dissent, so I was distressed. And then I got a phone call from somebody that said, "You won," and I said, "I don't know, are you sure about that?" And then thumbed back further and, earlier into the opinion and realized that we had one.
The majority opinion, which I joined, written by Chief Justice Marshall, took one avenue of legal analysis, which the United States Supreme Court has used in at least one other gay rights case, and that is that the government could not provide a sufficient reason for denying what these plaintiffs wanted.
Well, I thought it might come out on the basis of equal protection, but it didn't. They acknowledged, Justice Marshall acknowledged that she was changing the definition of marriage. And that's the province of the legislature. That's social engineering in its purest jurisprudential form, and it should not happen.
A huge number of people gathered, some for it and some against it, with signs and placards and everything else, on the plaza, which is in front of the courthouse. It's quite a big plaza. So the decision came out at 10 o'clock, and the proponents of gay marriage were very pleased, obviously, and the opponents were, at that point, very upset and angry, and they were shouting at each other and all that kind of thing. And I had to go down to CVS to get some toothpaste, so I walked out right through this mob. Nobody knew who I was, because we tend to be fairly anonymous. Maybe a few lawyers did, but they didn't say anything.
Since I was the only visibly gay leader within the ranks of the Bar Association, that I had a real personal interest in the issue of marriage equality. What I take away from Goodridge is that we were there at a point in time when a cause came before the court at the appropriate moment. And the court, in my humble esteem, in an act of bravery, did what courts are supposed to do. It exercised its judgment in a manner which was analytical, legalistic, and decisive.
What bothers me is the actions of judges and legislators in spheres of power that they don't have.
I certainly recognize that what happened with the Supreme Judicial Court of Massachusetts making the ruling that it did, and then Massachusetts stepping up and implementing it, that broke an historic barrier. And I will also say that it changed everything, because there was so much fear and misunderstanding and concern and speculation what would happen if same-sex couple married, and now we know the answer. There's loud joy.
I was coming from a deposition in Amherst, out in western Massachusetts, where I live. And my good friend and the current chief operating officer and then the general counsel for the Massachusetts Bar Association, Marty Healy, called me up. And as I was driving, I pulled over to the side of the road, and he told me that the decision had come down. The court had declared that the Massachusetts Constitution would not prohibit same-sex couples from marriage. And I pulled over the side of the road, as I said, because for one of the first and only times in my life, I was absolutely overwhelmed with emotion.